Hello and welcome to another episode of Chambers Expert Focus. I'm joined today by Juan Blanco Montoya and Pablo Gómez, Sainz, both partners at MGPS. Our conversation will focus on nearshoring, corporate and cross-border litigation considerations for making business in Mexico. Today, we'll be discussing how nearshoring is booming in Mexico, and the MGPS experts are going to provide a general approach for making business in Mexico, with a core insight on how to prevent cross-border litigation. Juan and Pablo, it's a pleasure to have you both feature on the podcast today.
Thank you very much to Chambers and to you, Rolanda, for having us. And it's a pleasure to be part of this.
Thank you very much.
Fantastic. So to kickstart our discussion, I'd like to know, under which corporate vehicles could an investor start business in Mexico?
Well, the most common mercantile company types to do business in Mexico are the limited liability company, o Sociedad de Responsabilidad Limitada, stock corporation, Sociedad Anónima, SA, and its variation, the investment promotion, stock corporation, o Sociedad Anónima Promotora de Inversión. Certainly, the most used type of company is the stock corporation. Its capital stock is represented by negotiable shares, and the liability of its shareholders is limited to the amount of their contribution to the capital stock. Certainly, as long as they do not act in creditors' fraud or with willful misconduct. The limited liability company, it's another type of mercantile company under Mexican legislation that regulates the transfer of participation in its corporate capital, since it requires the approval of the other partners. And this might be considered sometimes restricted by investors. However, this kind of company is most used by US wholly owned subsidiaries, as it is given the treatment of a partnership at the IRS, and therefore it is a pass-through entity for US income tax purposes. That's something to be kept in mind. Regarding the investment promotion of stock corporation, this kind of company allows to include certain provisions which are more natural to publicly traded corporations or companies, mainly focusing in control by minority shareholders. That's the reason why this type of company is commonly chosen by investors requiring complex structures or sophisticated structures such as private equity and venture capital funds, for instance.
Okay, that's interesting. And that leads me to ask, if a foreign company doesn't want to form a Mexican corporation, are there any other alternatives to make business in Mexico?
Yes, there are some other alternatives. For instance, it is possible to register in Mexico a branch of a foreign company to regularly perform acts of commerce. This process, attention, does not imply to incorporate a new Mexican company, but only to register the foreign company before Mexican authorities. In general terms, however, the Mexican branch has exactly the same tax treatment as any Mexican corporation. Also worth to be kept in mind, it's that all corporate decisions are made through the foreign entity. So in order not to compromise the continuity of the day-to-day operations of the Mexican branch, it is recommended to grant broad powers of attorney to a resident of Mexico that may later on delegate its authorities, giving the branch the capacity to act expeditiously in any particular case. Another possibility to facilitate operations in Mexico is to acquire or merge into an already existing Mexican company. This takes further relevance in regulated sectors such as banking and financial services and mining, telecom, etc., where acquiring a company having already certain permits, licenses, or authorizations may certainly accelerate to have a presence in Mexico. And finally, there is the JV. The JV that we all know, let me tell you something, joint ventures are not thoroughly regulated in Mexico, so it may take many forms. And we have, first of all, the simple or regular joint venture agreement, which is a private agreement governing the obligations, rights, and allocation of proceeds, and in general, be a specific business relationship between two or more parties to the agreement. That works exactly as in the US. Another kind of JV that is commonly used is the JV governing a special purpose vehicle, or SPV, whose purpose is to provide for the incorporation of this SPV, which could be a corporation, a partnership, a trust agreement also for a specific operation or endeavor. And it comes to my mind a third kind of JV, which is used to start operations in Mexico, which is the equity, the JV regulating the equity investment or in an existing company through a capital increase to join an ongoing Mexican business. This option certainly requires to have a partner, one or more, controlling a Mexican company, which is the entity that will receive the capital injection.
And so I think everybody would be keen to know what your advice is when it comes to protecting a foreign investor and avoiding a cross-border litigation.
Well, let me step in for a moment on this, because it is much more your area of practice. But I think that from a corporate perspective, the very precise piece of advice is to provide for a comprehensible and well-drafted forum jurisdiction clause. So it is clear that any procedure regarding any conflict or controversy will be conducted in Mexico under Mexican law. Is that correct, Gómez?
Yeah, that's correct, Pablo. Thank you very much. Also, as Pablo says, this idea would be to limit any possible claim that could be initiated out of Mexico by having this bulletproof choice of forum and jurisdiction clause. But also we have to include the applicable law. Yes, please consider that under Mexican law, the parties can agree on Mexican or foreign law, and that the judges will be able to have specific guidelines to interpret that foreign law. So one of the most important things is to state the law and also an express waiver regarding the law that you are not going to apply. Second, the parties must appoint a court in Mexico, either federal or local, but considering at least that such court is located where the address of one of the involved parties is, the place of execution of the contract, and the place of the location of the assets. Consequently, a well-drafted clause could prevent long-term disputes even before going into the actual merits of the case.
And I would add something, and probably we will go in more detail further in this presentation, but it is also advisable to consider including alternative mechanisms for solving controversies in the agreement centered in Mexico. It could be one or more. In case of having more than one, it is advisable to provide for different subsequent stages or phases, for instance, mediation, and if not successful, then arbitration. But I think that we will go further with this subject later on in the presentation.
And so I'd be curious to know what could be expected if the foreign investor fails to include a choice of law and forum clause.
Well, that of course happens a lot, no? We all know that business transactions are not always accompanied with a contract that includes this provision or that includes the correct provisions. If that is the case, it is important to say that Mexican law is very formalistic. We all come from a codex system. Then we would have to refer and find the applicable law to resolve each case. Speaking of business in Mexico, we usually refer to the Commerce Code. This is a federal act that applies to all natural persons, national or foreigner, Mexican companies, as the ones mentioned by my partner Pablo, and also foreign companies or their agencies that carry out commercial acts in Mexico. Also, this law perfectly defines what is to be considered a commerce act. This is every act that aims to have a profit. So with this, basically, when doing business in Mexico, the applicable law would generally be the Commerce Code and related mercantile-related acts. Regarding the jurisdiction, it's important to identify the nature of the acts and its material execution. This is, for example, are all the assets located in Mexico? Does it involve, for example, a real estate property? Or does this act has a specific formalities for its validity here in Mexico or in foreign countries? The above will always help us identify the connecting points. And by connecting points will be the best possible way to secure the jurisdiction in Mexico. Let me give you some examples. If, for example, this act executed by two parties requires a specific validity, such as an entry inscriptions before the public registry here in Mexico, well, then we can always secure jurisdiction in Mexico, right? Another example will be, for example, with lease or temporary use contracts, in which the law, Mexican law, states specifically that the law applicable will be the law of the place of their location, even though if those are owned by foreigners. Bearing that into consideration, one last example that comes to my mind in order to define the forum is generally the one that is defined by the address of the defendant. So here in Mexico, for example, if you were to file a claim and the office is located in Mexico, a foreign company could easily file a claim with a well representation to initiate that procedure. In this case, this trial or claim would normally prevent foreign courts from accepting other claims that are related and then avoid this costly cross-border litigation.
I think that's well explained. And next, I think it'd be interesting to learn what the basic considerations are for a foreign investor regarding litigation in Mexico.
Well, thank you. This is a really good question, because once you are going to start litigation in Mexico, I think it is of the essence at least to consider the statute of limitations, the evidence, and the serving notice. First, statute of limitations here in Mexico. Regarding Commerce Acts, we have a general rule of 10 years. I mean, that is a long term, right? Also, don't worry, we have further terms, such as a 2-year to claim damages and lost profits that starts counting from the moment that the damage is caused, and also shorter terms, which is a 15-day term to claim all the resolutions made by the minorities of the shareholders meeting. So in this case, although we have these long terms to prepare our claim, it is very important to refer to the evidence. Here in Mexico, we almost must bring all the documentations, all our proofs by the moment that we file the initial claim. Here in Mexico, we do not have discovery. This is a very important consideration because it differs, for example, from the US. Also, regarding the claims here in Mexico, one of the most important moments once the claim is initiated is the serving notice. This serving notice in Mexico has really extremely formal procedure. So, although that in Mexico we would also consider it as a form of art. For example, if you were to serve the claim to the defendant, you have to be very careful on how you do this process accompanied by the court. Why is this so important? Because once you serve the claim to the defendant then would have to challenge the jurisdiction of the court with the writ of response. And if the defendant fails to do so, then the court, according to Mexican law, will have jurisdiction. In other words, the competent judge is the one to whom the parties expressly submit their claim and or accept the response. It is important to say, regarding cross-border litigation, that derogatory letters are the formal way to call or summon to the claim foreign parties. Finally, just regarding litigation, I think it's also important to mention or to give a brief timeline of how does that procedure in Mexico happens. Well, we have a first instance, then we're going to have an appeal before a superior court. This could change. Sometimes we don't have this appeal, but most of the procedures here in Mexico have the appeal. And after the appeal, we have this final constitutional procedure that is filed against the final resolution of the trial. This is named the amparo directo. Amparo directo will be always filed before federal authorities. And in this procedure, we're going to review the due process during the whole trial. And also we could include claims regarding specific human rights that could be or that would be violated during the course of the trial. Finally, it's important also to say that we have amparo indirecto, that it's also a constitutional procedure that regards some specific violations that happen during the claim.
Okay, that's very interesting. And as a final question, I'd be keen to understand, what are the alternatives to litigation in Mexico?
Well, that's a very good question, precisely now in Mexico, because due to current political environment in Mexico and the discussions over the independence of judicial bodies in Mexico and the uncertainty of the direction of their decisions, it is a growing trend, and it will be even growing further, to include arbitration clauses in agreements subject to Mexican legislation, and also this considering the flexibility and level of technical specialization that may be reached by arbitration vis-a-vis a judicial litigation. Regarding the language of the arbitration clause, it is always our advice to our clients to stick as much as possible to the model of clause proposed by mediation or arbitration forum rules. If in any particular case it results indispensable to elaborate on the language or drafting of the clause, this additional language should be very carefully drafted and added to avoid having a null clause, which at the end would result in having to initiate a claim in terms of the regular jurisdictional procedure, correct?
Yes, that is correct, Pablo. As you mentioned right now, there is a presidential motion to amend the judicial branch in Mexico. Although this is a very political theme and that the final results of the election in Mexico are still pending, it is important to mention that the political power in office could be really close to have the numbers to amend the constitution. This, of course, or in this scenario that it's still pending, I have to insist on that. The actual president, who is going to leave office by next October 1st, pretends to change the whole nature of the judicial branch in our country. Among others, this motion includes having massive elections to appoint even the justices of the Supreme Court of Justice, along with all the circuit court and district court judges, also changing all the administrative and disciplinary bodies of the federal judicial power to center more control or power, and finally appointing these same modifications to all the local judicial systems in the country. When you think of this, it is very important to say that these modifications will be really relevant to the administration of justice in our country. And also it's important to say that I believe that those modifications are actually ineffective. I mean, not only from an economic point of view, but also it is important to say that we're going to have trouble finding impartial judges with great qualifications and secure positions that are going to be part now of these popular elections that obviously include social, cultural, and even financial problems. But focusing again on our today conversation, our main advice would be to insist in the importance to include effective alternative mechanisms for solving controversies here in Mexico in order to have a secure procedure to effectively engage and enforce those private agreements. Finally, we would also like to thank Chambers and hoping that this information is useful for all the audience. Should you have any questions or further inquiries, please visit our webpage and we will be happy to discuss. Thank you very much.
Thank you.
Indeed, it's been incredibly fruitful. So Juan and Pablo, I want to thank you very much for your time. It's been an incredibly insightful discussion on nearshoring as we've delved into the corporate and cross-border litigation considerations for making business in Mexico. Thank you very much for your time.
Thank you, Rolando. Thank you, Chambers.
Thank you. Goodbye.